I'm Susan Graham of Senior Edge Legal. What's the difference between a will and a trust? The big difference is when you have a will and someone dies, we're going to have to probate that person's estate. That means we have to go to court and have the court system oversee the handling of the administration of the estate. When you have a trust, if it's been properly set up, it's not necessary to go to court when someone dies. What I'm talking about is a will is to handle property that's owned in the name of the decedent. If that person owns real property or the cumulative value of their other titled assets exceed $100,000, so let's say they're a renter, but they have certificates of deposit, an RV, IRAs, a brokerage account, checking account, and so forth, and they all total up to more than $100,000, it will be necessary to go to court and probate their estate. That requires that someone submit the will to the court and ask that they be appointed. There's a court procedure to have them appointed. Then there's a requirement for a series of other documents to be filed with the court, an inventory, and later on an accounting showing what's happened with the funds, and then ultimately approval of the distribution of the assets. That's all under the umbrella of the court system. When you have a revocable trust and all the assets are actually titled in the name of the trust, that means the house is in the name of the trust, the brokerage account is in the name of the trust is named as the beneficiary of the IRA and the life insurance. When someone dies, it's not necessary to go to court and have the court oversee the supervision of that administration. What will happen is the successor trustee or the individual nominated by the person who created that trust, that backup person will then have a certified copy of the death certificate and take certain documents, and they can instantly start administering the trust estate. They get to pay the bills and sign on behalf of the person who died, now as the trustee of that trust, ultimately create an accounting showing what's happened with the money, show that to the people to whom the money is going to be distributed, and then once everybody agrees that it's all been handled appropriately, pass the assets out. So the trust is normally more efficient. It stays private. It never becomes a public document. And it's much easier on the family and the people who are handling that administration. A will is a public document. So once a will is filed with the court, anybody who's interested could go find out what was the plan and how many assets that person had. There's no perfect solution to say a will is good for everyone or a trust is good for everyone, but there certainly is a difference.